Good afternoon. This is Sean Golding with Golding & Golding, here to discuss a very important topic that's going to become more important depending on the outcome of certain cases, and as FBAR penalties become more and more enforced as a key priority. And that's, hey, can the IRS or U.S. government in general require a taxpayer to repatriate money from overseas in order to satisfy FBAR penalties in the United States, right? So, stated another way, can the IRS force you to grab your money from overseas and bring it back to the U.S. in order to make the U.S. government whole for ridiculous FBAR penalties that you might have sustained? So let's go through the basics a little bit here. FBAR penalties, right? You filed the FBAR late, or you never filed it at all, and you get assessed penalties. You get a chance to dispute it. You can't go to tax court, right? So you dispute it. You go back and forth with appeals. At the end of the day, they don't like you, right? So they say, okay, the penalties, they're solidified, that's it, and enforcement begins, right? You don't pay because you think it's absurd, and it is, and then it leads to the IRS filing a court case in district federal court, right? Next step, litigating the penalty. The government wants to show either criminal if you were indicted, but that's super rare. It's normally going to be willful civil, or non-willful civil, depending on the facts and circumstances. There's no bright line test, so it's referred to as the totality of the circumstance. Taxpayer, defendant tries to show that it was either non-willful in order to bring those penalties down significantly, or reasonable cause, because if it's reasonable cause, then the U.S. government can't issue penalties if you can show reasonable cause and not willful neglect. But unfortunately, it's not your day, so it's judgment against the taxpayer. So what happens next? Government wants to go after taxpayer, right? Taxpayer says, well, I don't have any money here in the U.S. to satisfy the judgment, so taxpayer's plan could be just let it lag. Maybe he or she is on green card or visa and is just going to high kick it back out of the United States, try not to worry about it too much. Recent case, what the government's trying to do is to seek or to make the taxpayer, force the taxpayer to repatriate or bring the money back from overseas, right? So the government's saying, hey, you may not have any money in the United States, but we know you have money outside of the United States, and we want you to get that money, bring it back to the United States to satisfy your FBAR penalty, okay? Different courts are probably going to rule differently until it goes all the way up, depending on what jurisdiction, facts, and circumstances of each case. But here's a few very important things to keep in mind about the government trying to force repatriation. Just because the money's overseas doesn't necessarily mean it's protected, right? There's no rule that says if you have money overseas, the government can't take it. In fact, U.S. persons are taxed on their worldwide income. They're required to disclose their global assets. When someone passes away, their estate is considered their entire estate, not just limited to the U.S. So there's that kind of in the background, right? In general, the mere fact that the money is outside of the U.S. doesn't mean it's outside of the clutches of the United States. Cooperation, right? The U.S. has entered into more than 110 foreign account tax compliance or FATCA agreements where other countries have agreed to reciprocal information with the United States regarding account holders. The U.S. has entered into more than 50 income tax treaties, and there's other types of agreements with different countries. And what that means is there's a cooperation, right? It's not uncommon for the United States government to work in tandem with a foreign government in order to enforce debts, right? Especially with Canada, right? If someone has a U.S. debt and the money's in Canada, the U.S. will work with the Canadian government in order to CRA, in order to get paid, right? So that's something to keep in mind. And depending on the type of foreign financial institution you're keeping your money in, it could be easier. If you're in a country that doesn't have a tax treaty and it's a local bank, it's going to be way harder for the U.S. government to get that, right? But if you're in, I don't know, if you're in Singapore at Citibank, or another country in which there's U.S. banks where they have foreign entities or versions of that bank, even if they're wholly owned subsidiaries, it doesn't matter, right? There's that connection with the United States, and that's going to make it way easier for the U.S. government in order to get that money back, okay? So if you've got FBAR penalties, or you've been initially assessed a penalty, goal is to try to get it resolved before. If you're out of compliance and you think you want to get into compliance, there's various programs the government offers. There's voluntary disclosure if you're willful. Penalties can be tough on that. There's the streamlined filing compliance procedures, which is streamlined domestic, streamlined foreign. There's delinquency procedures and reasonable cause. We have lots of free information available on our main website, goldinglawyers.com, and we have sub-websites depending on which topic you want to research. You can always reach out, schedule a reduced fee initial consultation if you think it's appropriate. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.